Good morning and welcome. My name is Tom McBride. I'm the Executive Director of the Nebraska Juvenile Justice Association, and on behalf of the association, I want to thank you for your participation in this installment of the NJJA webinar series. With the help and support of the Sherwood Foundation, NJJA has begun expansion of its three core values of education, leadership, and collaboration through a series of webinars and online resources for juvenile justice professionals in Nebraska. We'd also like to thank Voices for Children in Nebraska for their collaboration in this webinar. For more information on upcoming educational opportunities, please go to njja.org and sign up for our mailing list. There's a couple of housekeeping items before we begin today. Please make sure your name appears on the right-hand side of your screen as we are noting attendance for this live webinar session. Also, please utilize the chat function on the right side of your screen for all questions. In the interest of time, we ask that you save all your questions for the times outlined by the facilitator. This webinar is being recorded as a resource and will be able to be accessed through njja.org in the near future. More information about that will be sent out through our mailing list. Before I introduce our facilitator today, I think it's the importance of the training such as this, I believe, is summed up on one of the edifices at our Capitol building. It reads, "The salvation of the state is the watchfulness of the citizens." Each legislative session, hundreds of bills are introduced on a continuum of topics that covers our state. Sometimes these bills are suggested by our legislators themselves, brought forth to them by constituents, or even at the behest of the governor. Every bill that is introduced has consequences, intended and unintended. It rivals the law of physics in equal and opposite reaction. Each bill, if enacted, will have an effect that can ripple out like sticking your finger in a calm pool of water. It is up to us as citizens of this state to pay attention to legislation and offer our thoughts on a piece of legislation either in support of, opposition to, or simply providing information as a neutral observation. Reviewing these proposed pieces of legislation is an important part of our democracy. It is true that the salvation of the state is in the watchfulness of our citizens. I'd like to introduce our facilitator today. Again, it's Juliet Summers. Juliet's a policy coordinator at Voices for Children in Nebraska, and she's responsible for overseeing all of Voices for Children's policy research, analysis, advocacy efforts in the areas of child welfare and juvenile justice. Before joining Voices, Juliet served as a public defender representing children and families in juvenile court at Douglas County. She holds a law degree from the University of Chicago and a BA in political science from Duke University. She's a member of the Nebraska Bar. Juliet, thank you for leading us through this, and the seminar is yours.
My name is Juliet Summers, and I am the policy coordinator at Voices for Children in Nebraska. Prior to being in this role, I was a juvenile public defender in Douglas County, representing mostly teenagers accused of, or charged with delinquencies or status offenses, some child welfare work as well with that. So I have a little direct experience in the courtroom with juvenile justice, and that has really been my passion as I've transitioned into this work on the policy end of things, working with the legislature and with our state agencies to try and improve our systems in a research-based way to create better outcomes for kids. So thank you all for joining me today. A little bit about Voices for Children. If you don't know Voices for Children, we are a statewide, independent, nonprofit, nonpartisan child advocacy organization. We don't take any state or federal money to do the work that we do, which allows us to be an independent voice advocating for kids. And so with kids at the center of our work, our values are that we start from the research. Informed research drives our direction. Every year we put out a comprehensive data book called Kids Count. If you're interested in data relating to child well-being in the areas of health, education, child welfare, juvenile justice, economic stability, then definitely go to our website. You can get, it's fully searchable and available online there, all the most up-to-date data on kids in Nebraska. You can also request a hard copy. We'll send it to you for free. So we start from the data. We look at research into what works in our different public child serving systems, and then we work from there on the policy end. So when we see policies that are good, that the research or the data is telling us are working to create positive outcomes, we support it. When a policy is harmful, we fight it, and when it's missing, we can work to create it. And the final prong of our value statement is that community engagement is how we promote systems change. No one person or one entity can single-handedly change an enormous system that works for kids and families. So it's really a process where we all have to come together and make values-based decisions on what is best for the kids that we serve and how we can do our work better. So I'm going to start really briefly before getting into the substance of what bills have been introduced this session, just by giving a brief update on the legislature itself, a little Civics 101. So you may have heard this before. You may already know it. Feel free to ignore me for the next couple minutes, couple slides, if that's the case. But in Nebraska, we have one House, one legislature that convenes over a 2-year period. So we're in the 105th legislature right now. That 2-year period just started. 2017 is the first year of the biennium, and 2018 will be the second year. The first year of the biennium is long, quote-unquote long. It's 90 days from January through June, so there are some recess days built in there. And then the second year of the biennium is the short session, which is only 60 days from January through April. And as I said, we are in the first session of the 105th legislature right now. In a given session, each senator is entitled to bring as many or as few bills as they want to. They can just keep on writing bills till the cows come home, or they don't have to bring any. But they all have to be dropped or introduced by the 10th day of legislative session. So that means that any possible legislation that would be passed this year is already out there on the table and has been since January 18th was the 10th day of session. Each bill gets a public hearing. It gets assigned to a designated committee. Most of the committees, most of the bills we're going to talk about today have been assigned to the Judiciary Committee or sometimes the Health and Human Services Committee. Occasionally the Appropriations Committee is where the juvenile justice bills tend to live. But every bill, regardless how big or small, gets a public hearing, and anyone from the public, both Nebraska residents and otherwise, are entitled to come and speak in favor, in opposition, or neutrally on a bill. And then typically, because senators can bring so many bills, due to time constraints, we only have 90 days this year and 60 days next year. Only bills that get prioritized are likely to really make it through all the steps that have to happen. So every senator gets to choose one bill that's their priority bill. There's their number one. They want to make sure it gets heard. The Speaker of the House the chairman, the Speaker of the legislature gets to choose 25. And historically, the Speaker has chosen 25 bills that will be relatively uncontroversial, that don't have an enormous fiscal note or that are sort of those cleanup bills that need to happen. Historically, that's the way the Speaker has used those 25 priorities. That's not to say that that couldn't change. And then each committee itself gets 2 priority bills. So those are the bills that are going to be most likely to be heard and make it through the legislative process. So you can get involved with the legislature, and I encourage you to do so. Perhaps this webinar is your first step, or perhaps you are more of an expert than I am. So there are a number of ways you can get involved. By testifying at a public hearing on a bill. So if there are any bills that I talk about today that you think would really impact your work, or you have particular expertise or just a strong opinion about, you should feel free and entitled to come and tell the legislature, tell that committee what you're thinking about that. You can also contact members of the committee who are hearing a bill. So if you're not able to be present in person, you could send a letter, you could send an email, you could call, or you could contact your local representative. So even if your local state senator is not on that particular committee, if a bill gets out of committee, then it may well be heard on the floor, and you're entitled, as well as a constituent, to let your representative know what you're thinking about any legislation. And then well, I actually have one more thing that's not on this slide to say about this, but my almost final thing is an easy cheating sort of way to follow what's happening in the legislature is to join our listserv. So Voices for Children maintains a listserv, and during legislative session, we send out one email a week, an email blast, usually Monday or Tuesday, that gives a heads up on what's coming up in the legislature, what bills have been heard by committee, where the particular bills that we've prioritized are, stand, what's happening with them. And many of the bills that we'll talk about today we're going to be following, and we're going to be giving regular updates on through that listserv. So you should be able to click that hyperlink if you're interested in following. And then I didn't make this bullet point, but I encourage you to go explore the Nebraska Legislature website. So it's nebraskalegislature.gov is the home page. And when you get to that home page, one of the very first links you'll see is a link to introduced legislation. And that is going to take you to a chronological order, every bill that was introduced this year. There's 600-something of them. But what you can do is, after we've gone through this list of bills, anytime that works for you, you can get on the legislature website. You can get to that introduced legislation page. You can scroll down to the bill number you're interested in, and it'll take you to a home page for that bill that gives you a little update on what's going on with it. So that's my Legislature 101. If there are no questions about the legislative process, then I will move on to our webinar roadmap. So here's what we're going to go through today. First are some bills that would make proposed changes to substantive law or policy relating to juvenile justice. I started with in schools, and I'll give you the reasons for that in a minute when we get there. Policy or law relating to juvenile justice proceedings once kids are on probation or charged in the court. And then law or policy relating to juvenile justice after the case would close. So we'll start with kind of new substantive law that's being proposed, and then we'll move on to proposed changes to procedure or rules in juvenile justice proceedings. So the things that don't really alter, that like what can bring you into court or what can happen to you in court, but would change the way the court process would work or an administrative process would work. And then finally, very briefly, because this is not my area of expertise, but it is that kind of a year, we will touch base on proposed changes to the state budget that might affect funding for juvenile justice. So starting with schools, I wanted to include just a couple bills that were brought this year relating to school policy, because as a former lawyer who represented kids in the court, I could see how these two bills might directly impact the caseloads that folks would see in the juvenile court. I'm sure probably everyone on this call has heard the phrase the school-to-prison pipeline, which is this idea that the way children are treated in school, the way their behavior is responded to by teachers or principals or administration, can really impact whether they stay in school or whether they are sort of pushed out to the streets, to the courts, eventually to incarceration. And so any policies that we can wrap around students to keep them in schools are more likely to lead to their higher graduation rates. Policies that we adopt that tend to push even badly behaving kids out of schools, sending them the message that they're not welcome in class, are more likely to send them down the opposite road and into the court system where folks on this call will eventually meet them. So the first bill I wanted to bring to your attention was LB 428. Senator Vargas brought this bill, and it had
The caller has joined the conference.
It had a committee hearing a couple weeks ago before the Education Committee. What this bill would do is require the Nebraska Department of Education to create a model policy, and then all school districts to develop policies from that model policy supporting pregnant and parenting students. This model policy and then all the school policies would need to include anticipating and providing for absences that would be due to pregnancy or parenting, including reasonable medical appointments during a pregnancy or for a new dependent child. It would include providing alternative methods to keep pregnant or parenting students engaged in school, so reasonable accommodations for how they could do their coursework, offering tutoring if they can, if they can do coursework at home or have reduced hours, etc. Creating a lactation policy for breastfeeding mothers to have a hygienic place to be able to pump and store breast milk. And then identifying local child care providers or designating a staff person who would help student parents to place their children in child care facilities that would collaborate with the school so that there could be a connection between parent and child and school while the student parent would be in class. And the reason I think this bill applies to juvenile justice is I personally, as a lawyer, have represented young folks who had truancy proceedings brought against them, in part at least because they were pregnant or parenting. And I know that there have been substantial efforts made to reduce those kinds of filings in juvenile court in recent years, but I think our perspective of Voices for Children would be any policies our schools can wrap around students who find themselves to be pregnant or parenting will be more likely to keep them in school rather than driving them out and having to make those hard choices between caring for their child and getting their education. And then sort of by contrast, the other education bill I'm going to talk to you about today is LB 595 by Senator Groney brought this bill. And it actually has a hearing tomorrow afternoon, which would permit the use of physical force, physical restraint, or removal by teachers against students for student behavior in class. So there's some sort of different requirements. I'll actually pull them all up here so you can compare and contrast the language. Physical force or physical restraint would be permitted in the case of subduing a student who becomes physically violent toward himself or others. Just physical restraint would be permitted to subdue a student who exhibits destructive behavior towards school property. And then removal from class, and it doesn't specify whether that includes using physical force or restraint to do so, but removal from class would be permitted in a few different circumstances. So when there's documented repeated interference with a teacher's ability to, quote, communicate effectively or of other students to learn, when the behavior is so, quote, unruly, disruptive, or abusive to interfere with, again, that effective communication or ability to learn, or just more generally, other disruptive acts that merit discipline. There is a question from a guest, which I will respond to right now. Will it require that education receive training in an approved physical intervention program? And no, the bill does not specify that. I'm also really, our organization, I guess I should say, give fair notice, will be opposing this bill tomorrow, in part because the language is really broad. There's no parameters of reasonable force or restraint or what that might look like or not look like. And then it actually specifies that any force or restraint used under these circumstances may not give rise to legal action or an administrative response. So a teacher who would use physical force to subdue a student or physical restraint to, to remove a student from class, per this bill, it would, the bill also says it would not be considered corporal punishment, and it says, like the school couldn't respond to that teacher's behavior. And it doesn't, again, specify reasonability or anything like that. And then the other piece, so going back to the idea of the school-to-prison pipeline, is that the bill also says that if a teacher makes a decision to remove a child, then the principal may not return the child to the classroom without the teacher's permission. So there's, I think, a real possibility of the relationship between student and teacher being lost or fractured, and then no ability for the principal to intervene and say, no, we really need to keep this child in the traditional classroom as opposed to in some form of suspension or otherwise. A question from Renee. Would you support it if there were more specifics? I think that's a hard question to answer. I don't know. It would depend on what the specifics were. I think generally my organization is very concerned about the idea of using physical force or physical restraint in the classroom. And also the language, the current language is so broad. So words like unruly, disruptive, or abusive, or other disruptive acts, you know, if you look at the national research into suspensions and expulsions, they're really disproportionate when it comes to race and ethnicity. And a lot of it comes down to that quote-unquote unruly behavior. We see African American students being suspended or expelled from school for quote-unquote unruly behavior at much, much higher rates than their white peers, which is not necessarily dangerous behavior, not even necessarily disrupting the class, or there could be a different kind of intervention. So I think our concern would be that that the language is so broad it could be used disproportionately in different classrooms or by different teachers. Different teachers might interpret that differently. So I think we have a lot of concerns on that front. And I see Liddy Daniels is making a similar comment that unruly and disruptive is too broad. Some teachers might interpret that very strictly as in talking too much, et cetera, right? We've seen some reports from other states, not from Nebraska, but you know, students being suspended for unruly behavior like chewing gum. So it can be very, very broadly interpreted. So moving on, those were the two bills I wanted to highlight about schools that could potentially relate to juvenile justice. And I'll move on to a little more direct legislation that would affect kids once they're in the juvenile court or on probation. So the first is Senator Christ, who's been pretty involved with some juvenile justice legislation in recent years. He brought a bill, LB 8, which would change juvenile probation system of administrative sanctions. Nebraska has a statute for how probation can respond when a youth on probation is violating the terms of their probation contract. But that statute, as it currently exists, is very prescriptive, and it's actually copy-pasted from the adult probation statute. So it's not necessarily developmentally appropriate to young people, to adolescents who would be on probation. So this bill was the work of a number of stakeholders, and as far as I'm aware at this point, has no opposition. It's had fairly broad support of folks involved in the juvenile justice system, including probation, has been strongly in support of it. What it would do is it would change the current administrative sanctions statute to have a more flexible framework for when youth are both in and out of compliance with probation contract or you know, the minor technical details of their court orders. And this would give probation officers a little more flexibility when youth are doing really well on probation or really well comparative to their prior behavior. Probation officers could offer incentives, so positive response. I think anyone who has worked with young people or you know, teachers would know that you're supposed to have like a 4-to-1 positive incentive to negative sanction ratio to really get kids invested in whatever you're trying to get them invested in. So this would allow probation officers to use positive feedback for youth on probation. And then also to respond to minor violations of probation with swift and immediate but developmentally appropriate sanction options. So it couldn't change the underlying terms of the probation, like, you know, change a treatment level or something like that. But the probation officer wouldn't have to file a motion to revoke, which could take months and get back into court, in order to do something like require the young person to see their probation officer more often or change the curfew. Sanctions like that can have that kind of immediate impact, which we also know is developmentally appropriate for young people. If you wait months and months and months to punish them for something that they did, they've already, may have forgotten by that point. The force or effectiveness of the sanction is lost a little bit. The bill also, so in that regard, eliminates the requirement that probation notify county attorneys of every single violation, but it does require probation to track sanctions that they've imposed, successful completion of those sanctions, and or failure to complete those sanctions, and then positive incentives as well, and provide that information to any party upon request. And it further clarifies that detention is not appropriate when the only thing going on is a technical violation of probation. So, like consistently being a little bit late for curfew or skipping out some afternoons of classes. Those are behaviors that need sanction. They need an appropriate and swift response, but they don't necessarily rise to the level of dangerousness that we would otherwise require for secure detention. So that is LB 8. Moving on, LB 298 is Senator Baker has brought this bill. It'll be before the Judiciary Committee. It would apply provisions of the Nebraska Strengthening Families Act that went into effect this past year to youth on probation. So I don't know how familiar everyone on the call is with the Nebraska Strengthening Families Act, but it's essentially attempting to achieve some form of normalcy for youth in foster care before the courts. And this bill would extend some of those protections to kids who would be juvenile justice involved. One of those things is the reasonable prudent parent standard. So if there is a youth who's on probation in a foster care placement or in an out-of-home placement, the caregiver would be allowed to utilize the reasonable prudent parent standard to make parenting decisions for that youth, as long as they were otherwise in compliance with court orders. And the youth would be entitled to get notice of the rights available to them under the Nebraska Strengthening Families Act in going out of home. It would also require child care institutions, facilities that house youth on probation, as well as in the foster care system, and YRTCs to develop a written normalcy plan and provide an annual normalcy report for their youth in their care. So just because a young person is placed out of their home or in a congregate care setting doesn't mean that they should lose all access to sociocultural activities, religious activities, even your sports or your extracurricular activities that sort of define otherwise normal teenagehood. And the idea behind this provision, I think, was rather than being prescriptive and saying every youth in every placement is entitled to XYZ, different placements are going to look different just by their nature, by their level of security, or by the mandates of their treatment program. So asking those institutions that youth in our court system are placed in to develop those plans themselves of how, to the best of their ability, they're going to foster normalcy for the youth in their care was the way this bill was structured instead. LB 623, Senator Wishart has brought this bill, and it would change provisions relating to assault on an officer or healthcare provider. I'll confess I wasn't very familiar with this statute before, and it's a little wonky the way the language is changed. So some people on the call may actually know or understand the changes that are being made better than me, but from my read,
The caller
Kathy Miller,
has left the conference.
what I can tell is it expands the definition of officer in this provision of the criminal code for where someone, an assault on an officer is a crime. And it makes that public safety officer rather than just officer. And then it explicitly includes probation officers and detention facility employees in the list of who is considered a public safety officer, so that, say, a probation officer in the furtherance of their duties is assaulted by a young person, that young person would be chargeable with the felony level crime of assault on a public safety officer. And for this purpose, just for this statute, detention facility includes not just, like county jails, but also secure and staff secure juvenile detention facilities, YRTC, and I think even shelter placement. Can someone tell me in the chat, can you see the bottom bullet of my PowerPoint? I need to figure out how to zoom out somehow so I can make sure I'm catching every sentence. Yeah, I can't either. So apologies for that. I think I'm giving it to you verbally from the best of my memory, but I don't know how to fix it. Okay, moving on. So the last piece of the actual bills that have been brought we're going to talk about is different we're still on substance. So after case closure, there are a couple bills that would affect the way young people who are exiting our juvenile justice system could be treated or handled. The first is LB 179. So Senator Bowles has been working for a couple years on an interest in legislation that would provide transitional supports or services to youth who are aging out of probation without, supportive family structures. So she brought a bill last year, LB 866, that got out of committee but did not get a priority, so it didn't get heard. And then she brought an interim study to continue examining the question. And simultaneously, the Nebraska Children's Commission has an advisory committee looking at the HHS's Bridge to Independence program. And this advisory committee had a task force and has examined the question of how to expand that program to include other youth who would really benefit from the supports that it can offer. So the bill this year that Senator Bowles has brought is 179. And what it would do is it would expand eligibility to Bridge to Independence to youth aging out of juvenile probation who meet a couple of requirements. The first would be that they have to be in a court-ordered out-of-home placement on their 19th birthday. So their case hasn't been able to close before they turn 19. They're residing in an out-of-home placement that the court has ordered for them, so it's not runaway, but something like, a group home or potentially even detention if they're just waiting there because they lack somewhere else to go. And that's what the second bullet point is trying to capture. Oh, thanks, Kim. That is helpful. The moderator can press *5 to affect name announcing and exit chimes. Thank you. So these two bullets between the two of them are trying to capture a pretty small population of young folks who probably their probation case could have closed. They've been successful or, they're doing well in the placement they're in, but they don't have a home to return to. And for whatever reason, a 3A case, child welfare case hasn't been filed against the family, potentially based on the youth's age. If the young person is 18, then, such a filing really can't be filed. But nonetheless, they're stuck in out-of-home placement, and they're just waiting there as long as they can until they turn 19 when juvenile court jurisdiction automatically terminates. So this program would say youth who meet those two requirements, that they're in that out-of-home placement and they've received a court order saying that that placement is necessary to meet the best interests of the youth, would be eligible to enter Bridge to Independence as it currently exists, to have transition planning between probation and the department in order to get them into that program. And then they'd have to meet the ongoing requirements of Bridge to Independence to stay in the program. So they'd have to be in continuing education, whether that would be completing their high school degree or getting a GED or going on to college, or they would have to be employed 40 hours a week, or they'd have to be pursuing one of those two options. And with the Bridge to Independence program, then, if they are complying with those requirements, they would get access to the stipend to assist them with housing so that they would remain not homeless, and a case independence coordinator or case manager to touch in with them and help them navigate those tricky years becoming an adult after system involvement. I should say on LB 179, I anticipate this would not be inexpensive of a program model, and the work that was done in the interim study indicated that there would be somewhere in the realm of $2 million cost for the first couple years getting it off the ground. So that may, in the budget year we're in, be a difficult lift, but certainly a worthy program to support for these young people who otherwise don't have supports. And there's always potential with the legislature in the first session, if it can get out of committee. Then even if it doesn't move forward this year because of the budget, or if no one prioritizes it, it could potentially be heard early on next year when perhaps there would be a different fiscal climate. LB 556, Senator Halloran, who is a new senator, brought this bill. And it does a couple different things. I'm only going to talk about one piece of it. It creates a couple new offenses, and the one we're going to focus on is a new criminal offense called possession of a firearm by a prohibited juvenile offender. So it would create a new felony offense for a young person up to the age of 25 who is found in possession of a firearm and who has been previously adjudicated as a juvenile offender for certain enumerated felony offenses. And you can, if you're very interested in this bill, you can click over to the bill. It's kind of a long list, but generally speaking, they're the higher level felony offenses. So, your first degree felonies, like, obviously murder or, first degree assault or, use of a firearm to commit a felony, charges like that. But there's kind of a list of them. So if you're interested, click on over to LB 556 and take a look. It does provide an exemption, so for young people who may meet those requirements, they may have previously had one of these charges in juvenile court, and they're under the age of 25, but they join the military. So if you're in the military, you're exempted. And it also provides an avenue for others who are not in the military to petition the court to be exempted based on their behavior since the adjudication. And they would have to petition, depending on their age and if their case is still open, petition either the juvenile court, the juvenile adjudicating court, or go back a few years later and petition the district court. I will note that looking at this bill, it doesn't appear to make any provision for how it would interact with juvenile sealing of records. So, so if a young person were to be adjudicated on one of these charges in juvenile court, but then be successful on probation and get their records sealed, it's not clear to me whether or how this bill would, override that, whether some kind of record would be nonetheless maintained or held open for the purposes of this kind of charge, or if sealing of record would be, a perfect defense or protection against this future charge. It doesn't really specify or clarify that. And it also, as I said, it cuts off the age of the age that you could be charged for this at 25. So, the 26-year-old who had previously been adjudicated on one of these offenses would not be eligible to pick up this charge. So if there aren't any questions about any of those substantive bills, I'll move on to procedural changes or rules changes that might affect some of the work that you do. Excuse me. The first, briefly, LB 10, Senator Christ. This bill has been brought for a number of years. Anyone who follows the legislature knows for a number of years different senators have tried to bring a bill increasing the number of juvenile court judges in Douglas County, where there is statistically just a much higher caseload coming into those courts before each of those judges. The initial bill would increase the number of judges from 6 to 5. The Judiciary Committee already heard this bill, and I believe it has come out of committee with a proposed amendment to actually make it 7 judges rather than 5 judges. But the way the amendment process works is if the bill would come to the floor would debate whether to adopt that amendment or not. They could still hear the underlying bill even if the amendment wasn't adopted. LB 11 would change the timing of appeal on orders to transfer a case between juvenile and criminal court. So a couple years ago, the legislature upended the way Nebraska had done things in terms of where young people would see their cases originate. Previously, there was sort of a great deal of discretion in the charging process for the county attorney whether to charge a case in county, district, or juvenile court. And what LB 464 did a few years ago was say, we're going to start most cases, nearly all cases, based on age when someone is 17 or younger in the juvenile court, and then allow the county attorney in appropriate cases to file a motion to transfer the case from juvenile to criminal court. So there were a couple Supreme Court holdings this year arising from that legislation, kind of looking at this new statutory framework. And the Supreme Court held that a transfer, so when a juvenile court has ordered that the case transfer out of juvenile court to criminal court, it doesn't affect a substantial right and thus is not a final order for the purposes of appeal. The young person would have to wait all the way through criminal trial and sentencing, and then they could appeal the case. So what this bill would do instead would be to say, no, timing is so important. There's a limited number of years that you can work with a young person. So let's make sure that this decision is right and is as expedited and timely a way as possible. And it creates a statutory right to immediately appeal an order transferring a case from juvenile to county or district court or retaining a case in county or district court. So rather than wait all the way to the end of proceedings to have that appeal, it would just move it up. LB 158 is another sort of follow-up piece of legislation. Last year, LB 894 passed, which did a bunch of things related to juvenile justice, but one of them was to provide automatic early appointment of legal counsel in all juvenile proceedings, but after an amendment on the floor, this part applied only to Nebraska's 3 largest counties, so where there were populations of 150,000 or more. So the current state of the law is that in Douglas, Lancaster, and Sarpy County, every youth who's charged in juvenile court, at the time the paperwork is filed, the petition is filed, they get appointed an attorney, and that attorney has the ability to confer with them before they even come into the first appearance. This bill, LB 158 this year, would extend that, would try again to go statewide with this and say that, if it's good for kids in Lancaster, Sarpy, and Douglas, it should be good for kids all across Nebraska to have a lawyer as early as possible to advise them about what's going to happen in court, what their rights are, but also how to handle the case. Is this something we should fight, or is this something really we should work out an agreement to potentially do at that very first hearing? And that was heard by the Judiciary Committee last week or the week before, and I just heard actually that it came out of Judiciary Committee with unanimous support, so it's now up for the legislature to consider as a whole. LB 434 makes a small but potentially significant change to the use of video conferencing or teleconferencing in evidentiary proceedings. So currently, non-evidentiary proceedings in juvenile court, it's sort of at the judge's call whether to use telephonic or video conferencing instead of in-person court hearing. And this bill would kind of extend that to evidentiary hearings as well, where currently, if there's an evidentiary proceeding, where lawyers might question witnesses, or there might be evidence produced for or against a particular recommendation. It's required that all parties stipulate if the hearing's not going to be in person, if it'll be telephonic or video instead. This bill would change that. It would remove the requirement of stipulation, and it would just say the court can so order to have it by phone or have it by video conference as long as it's in a manner that ensures, quote, due process rights of all parties. The next one, LB 658, again, it does a couple things. The only one I'm going to mention to you is that it officially requires that the report of any evaluation of a juvenile as part of an adjudication or disposition proceeding has to be made available to all parties at least 15 days prior to the hearing. I sort of believed that was already the case either in court rule or perhaps somewhere in statute, but this would make it firm and in law that if there is an evaluation that's been done, the report needs to be back and available to all parties 15 days prior so they can prepare. And another one on reports, LB 516 is a follow-up again from last year's LB 894. There was a piece of that bill that required reporting of use of solitary confinement, or it was termed room confinement in that bill, of juveniles in all different kinds of facilities where juveniles might be housed. This bill provides, and those reports were meant to go to the Office of the Inspector General, and I know that office has been collecting reports from facilities this past year, and that office is required then to report to the legislature the findings or the data that's coming from facilities on how many hours youth are spending in solitary confinement as defined by the statute. And this bill would add an additional clarification that the names or identifying information needs to be redacted, but otherwise the data needs to be disaggregated. So you can't just say, as a facility as a whole, we had youth who served in total, 1,000 hours of solitary confinement. It needs to be disaggregated by, on this day, youth X was placed in solitary confinement and they were removed 3 days later, and here are the reasons why they were in there, et cetera. And then the bill also makes intentional noncompliance with reporting a Class 5 misdemeanor. So if a reporter under this statute is refusing to comply, it does have that kind of hammer in there saying you can't, if you're covered by this statute, you can't intentionally not comply with its requirements. Are there any questions about any of these procedural things? Okay, then I will move on very briefly to the area of my least expertise, so end on a high note. But obviously, everyone knows this is a tough budget year. Nebraska is in a substantial deficit. Mostly what the legislators have been talking about on the floor thus far is budget issues, budget concerns, trying to fix the deficit that we currently are living in and proposals to ameliorate it going forward. And juvenile justice is no exception to those conversations. So there are sort of two places you can look. Right now, the forward-looking state budget it's a series of proposals. So there's the governor's proposal, which includes all the agencies covered by the governor. You can find that on the state treasurer's website, which is where I got some of this more detailed information. And then that plan is encapsulated in LB 337, which was brought by, I forget who it was brought by, I apologize, but it should be heard this week, this Wednesday, in front of the Appropriations Committee. There's that bill that gets a hearing, and then all of the agencies come individually before the Appropriations Committee to make comments or proposals specific to their agency. So it's kind of a convoluted process. But what I'm going to tell you about today is based on sort of that preliminary information from like the governor's initial proposals were, and then obviously it can be amended by the legislature as they see fit coming out of these hearings. So there was a proposed modification of 4% reduction of general funds to the Supreme Court, which would include some cuts to juvenile justice services or probation. A reduction of the community-based juvenile services aid fund that's run through the Crime Commission and goes to counties in order to support alternatives to detention, diversion, et cetera, to reduce that by $180,000. It would eliminate ongoing state investment in the Rural Practice Loan Repayment Assistance Funding Program, so supporting, doing some loan forgiveness for lawyers who choose to practice in rural areas. And then it would increase funding to improve staffing ratios at YRTC to bring them in line with federal Prison Rape Elimination Act requirements, and also to bring them in line with treatment facility staffing ratios as opposed to more correctional staffing ratios. So that is what I've got for you. We have about 10 minutes. I've got my contact information here, so if you don't have a question right off the top of your head but think of one later, please always feel free to reach out to me. But does anyone have any questions, comments, concerns about any of the foregoing? And Carrie, if you are interested in this information, I would direct you again to the state treasurer's website, or even you can go to the governor's homepage and find their proposed budget for the 2017-2018 biennium. And that's where they really break it down agency by agency of what the agency's proposals were and what the governor is recommending. That's where we pulled some of this information. That's not to say that that's how it will continue, again, that's what the legislature will choose to do or not do. The Appropriations Committee gets to modify this proposal as they see fit, and then the legislature is obligated to produce, constitutionally obligated to produce a balanced budget by the end of session. So, it could well be different, what comes through the session. But if you're interested, that's where I pulled these initial proposals. And then you can follow LB 337's path through the Appropriations Committee, through the legislature, to see how it gets amended or changed. LB 8, I'm concerned about incentives for good behavior. How do we encourage positive behavior simply for the personal satisfaction of making positive behavioral choices? That's a great point. I have heard in some conversations with folks from probation who are working on developing this matrix system that that some of the incentives they're intending to use are as simple as calling it out, responding positively to positive behavior and making a concerted effort to let the young person know when they're doing well. So that's not to say that it would all be tangible, you get a gift card if you do really well or something like that. Because, yeah, I think obviously developmentally what you are trying to instill is that personal satisfaction, that it is, it's good to do well. But I think as many of us who work with youth in probation know that some kids who come through the system may not have had a lot of experience of positive reinforcement. So even hearing those words of "you're doing really well" could be a special thing to some of them. Are there any other questions? Well, then, thank you all so much for joining us. Again, I'll put my contact info back up. And as I said, if there was anything on here that you were interested in following, feel free to join our listserv. If you go to our homepage, you can find a link to it, because this is what we do every day. We will be following these bills through the legislature and keeping folks updated. Thank you so much for your time, and thank you, NJJA, for allowing me to give this information out today.
Thank you, Juliet, for your presentation and getting us all up to speed on these legislative bills. We would also like to thank Voices, also in collaborating in this training process. But we especially thank you, Juliet, for your tireless efforts on behalf of Nebraska's young people and their families. And for those of you joining in on this event, thank you, and please watch for more announcements of upcoming NJJA-sponsored web-based training events on a variety of topics. So this concludes our presentation, but we do encourage you to also plan your schedule so you can attend the annual NJJA conference to be held again in Kearney, Nebraska on May 17th, 18th, and 19th of 2017. And on behalf of everyone at Nebraska Juvenile Justice Association, we thank you.